Thanks, everyone. Welcome back to Real Estate Syndicator Live, episode 5. It's only been 5 weeks already, so we're doing super excited. Thanks for everyone to be here. Really appreciate you. Talking about asset protection 101 for syndicators today. A couple of announcements real quick. Next week, we're going to talk about how to legally incorporate capital raisers into your sponsor team. That's a topic that's come up quite a bit. So if you've got co-sponsors and you're trying to figure out how to bring somebody else who's going to be raising capital or how to structure that properly. We'll talk through that. And then I'm really excited about the week following. I've got Russell Gray, co-host of the Real Estate Guys, is going to come in and talk to us about how to ensure you have an endless list of passive investors through building your brand and building your network. So super excited about that. That's going to be, what is that? March 30th for Russell Gray. So excited about that. So without further ado, today, Asset Protection 101. I'm just going to talk for a little bit. I really just want to get the juices flowing, but I really just want to focus on Q&A, make sure I'm answering your specific questions. I'm going to do something that I only did, I think, on the first episode, which is I'm going to share a screen because I got to have at least a schematic up there. And I'm just going to walk through the schematic and kind of outline the thinking behind this sort of basic schematic. And then I'll open it up to questions. This is just kind of your, I don't want to say your basic, it's probably covers 90% of you guys will probably do something like this. But once we go through that, you'll have some questions. And obviously there's a level 2 and a level 3. I mean, you can have asset protection trust, you can do equity stripping strategies, a lot of things that we can do. But I'm going to go ahead and share my screen, and it'll probably be really fancy, as you guys know how I am, super fancy with my schematic. So this is, I did a flip chart Friday. This is coming out straight from my flip chart. So I don't know if you guys have seen a video that's circulating about Pace Morby has an interview with me, and he's very impressed about the multicolored structure that I put together. I think he was more impressed with the 3 colored markers than he was with the actual schematic. But so this is what, again, 90% of you guys will have this as at least your basic strategy. And with asset protection, just to kind of give you the high level view to begin with, the sole purpose of asset protection is to separate the valuable assets that you have away from the liability producing assets. So liability producing assets would be active businesses, would be your management companies, anything where you're actively involved. And then your assets, your valuable assets, you want to hold that in something that doesn't do business with anyone. Right. So that's what we call a holding company. And the whole job here is to separate those two out, because you never want to have valuable assets in a liability producing entity, because what happens when that liability producing entity gets sued, you want to make sure it doesn't have anything. Right. That's the whole goal here. I will start by saying my little spiel about insurance. As always, insurance is always your first line of defense. If anybody tells you that you shouldn't have insurance or this asset protection structure will cover you, always have insurance as your first line of defense. My issue with insurance, really, as you guys have heard, is threefold. Number one, insurance companies make a living by excluding, coverage. And so, unless you have an attorney or an insurance attorney review your policy, which I highly recommend, by the way, it's so freaking complicated that they'll exclude something. I always joke on page 74, and then they'll put it back in page 102, and then they'll take it back out again on page 200. So a lot of people think they're insured for whatever they're paying their premiums for, and they don't realize that they're not insured until it's time to actually collect. And then you get that denial letter because of some exclusion on some footnote on buried somewhere. So that's my first issue. Second issue is just most people are underinsured, meaning they may have $1 million policy or maybe a $2 million policy or $5 million policy, but we're real estate investors, most of us here on the call. And so, I've countless examples of really big time tragedies that happen. The one I like to use a lot, not like to use, but from my alma mater up at UC Berkeley, there was a collapse of a balcony. There's about 6 or 7 students, college kids having a good time, having some drinks, and the balcony collapses. And I think all 6 died or something. And so your $2 million policy is not really going to do much at that point. So insurance is important, but it's not always there. Think of these entities as sort of a backstop to your insurance policy. So hopefully the insurance will cover you. Maybe 60, 70, 80% of the time it will. But in those instances where it doesn't, and it's not there or it's underinsured, you want to have a backstop. And that's what these entities are meant to convey over here. Let me just move the stuff around here a little bit. I don't know if you guys can see all this stuff. Hopefully you can't. You cannot see all the stuff I'm trying to admit here. So typically on a syndication, you're going to have what I call a syndication entity, and a syndication LLC. And most of the time, we're going to talk about LLCs, although theoretically you could have limited partnerships as well, but I'll use those interchangeably. But you're going to create a syndication LLC that's going to own the property. This particular example, it was a property, I think in Atlanta, Georgia. So that's why it says GA for Georgia. But the syndication LLC is where your investors come in. That's actually the security that you're issuing. That's why securities laws are involved. You're issuing shares, or in this case, membership units in the syndication LLC. This company is actually called the issuer. That's the technical term. That issuer is issuing securities to the investors who are exchanging membership units for some dollar amount. And usually that syndication LLC then also is the owner of the property. Now, some of you guys already know, lately there's been a move for some of the lenders that are requiring this entity to actually be set up in Delaware, because Delaware's got some pretty robust corporate statutes in a specific court. But so sometimes it might have to be done in a different state and then registered back in the state where the property is located, like in this case in Georgia. And then again, some lenders like to have a buffer entity in terms of between the syndication LLC and the owner. They want the borrower to be the owner, and they don't want it to have all these investors. And so the lender may require a different structure. But if it was left up to us, we wouldn't have anything else other than this particular syndication LLC that's in the state where the property is located. I mean, you can set it up wherever, but you'll always have to register it back in the state where the property is located, because that's where the business is happening. And if anything were to happen at the property level, slip and fall, balcony collapses, or, boiler explodes, whatever happens here, it doesn't matter where you set up this entity, that local jurisdiction is going to apply. So Georgia law will apply no matter where you set up this entity, which is really why it's kind of a waste to some extent to set it up somewhere else and then register it back into the state. You're paying twice. And again, if something were to happen here, the local jurisdiction is going to be the law that will apply. And then, as you guys know, at least those who work with us, and I think most people do this, we generally separate the classes in that syndication LLC into two. One is all of your investors. And in this example, I'm just assuming it's an 80-20 split, but obviously it can be 70-30, 75-25, whatever you guys want. And so we create different classes primarily for control. There's two reasons why we create separate classes. One is control, because we want to make sure that all of the voting rights is held here in the second class that the sponsors own. We'll talk about that in a second. That's the main reason we do it, for control. But also, if you're giving the investors some kind of a preferential treatment, like a preferred return or just anything that's preferential above and beyond the sponsors, and it makes it a lot easier to do that, because you can just give that preferential treatment to the entire class, which is just your investors. So that's the reason we do the two classes. And so the investors will come in here, and then you guys will own this is called the carried interest, ideally in some kind of a holding company. And this is the reason we hold this in a holding company, is because, again, this 20% is really where the valuable asset is, right? That's really why you're doing this. It's not for the acquisition fee or the asset management fee. It's really for that 20% of the rents, 20% of the profit on the back end. That's really the valuable stuff. So we want to make sure that's protected to the maximum extent possible. And we do that by usually creating a holding company. That's why I put it in green. It's kind of a safe place. And this holding company, it's very important to understand that a holding company which owns all of the valuable assets, and whether it's a real estate LLC or whether it's another property LLC, or if it's precious metals or whatever asset it has, this company does absolutely nothing. That's the first point I want to emphasize. A holding company doesn't do anything. It literally sits there in whatever jurisdiction you created it. We'll talk about that in a second. Just sits there almost like with a bucket, holding a bucket. And in this case, the LLC membership units are in that bucket. Or if you've got cash in a bank account, it's sitting there with a bucket with cash. And so I'm not really worried about your cash jumping out and suing you. I'm not worried about your precious metals jumping up and suing you. I'm not worried about your art collection or your wine collection or whatever valuable asset you have there to jump out and sue you. I'm not worried about the membership, the membership certificates, the LLC membership. That's basically like a stock certificate. I'm not worried about your stocks jumping out and suing you. So that's what we want to hold in these holding companies, is safe assets, number one. And number two, it conducts absolutely no business with anyone. So there's really no opportunity for anybody to sue the holding company, because it's not doing any business with anyone. So that's kind of an important point I want to emphasize on that one. And then finally over here is the management LLC, right? The manager of this syndication LLC. And this is what we typically call, from a vernacular standpoint, the GP. Whenever you hear the GP, one of my pet peeves is that, first of all, it's not really a GP, right? So it's usually managers and members, not limited partners and GPs, but that's okay. We use vernacular and everybody understands that. I'm okay with that. But the important thing to understand is that the GP is really the management LLC, right? And I think one of the biggest mistakes I see out there is they consider the GP both of these entities, both the management and the holding. And a lot of times the GP will also not only be the manager, but also own the 20%. And that's basically the big no-no. And the reason I originally did this video, and the reason I'm doing this is because the management LLC is the one that makes all the decisions. And so that's the liability producing entity. In fact, you want it to be I call it the liability sucking entity, because it sucks up all the liability because it's the one that makes all the decisions. So that's, if a lawsuit happens, everybody's going to get sued, but ultimately the entity that really belongs there is going to be the management LLC. That's the entity making the decisions. And so if somebody did something wrong, was negligent, didn't do something they were supposed to do, that's going to be on the management LLC. So when that company gets sued, I don't want the management LLC owning anything, right? I don't want it. That's why it's not connected by a straight line. It's a little dotted line, because it just denotes that it's managing. There's a contractual arrangement between these two entities, but there's no ownership. So when that company gets sued in the near future, the idea would be that you'd basically hand over the keys. Like, you don't care that it got sued, because all it's really going to have is ideally an insurance policy, number one, sort of an E&O policy or something. And number two, it's going to have a little bit of cash, right? You got to have cash to operate, and maybe it's got 2 or 3 months worth of operating cash. But anything above that, you want to get that out of that danger zone and distribute it to the sponsors or the owners of this company, so that it's not fair game, so that when that lawsuit happens, there's nothing for them to take. You could literally hand over the keys. Now, if you get to the point where, a little bit more advanced here, but if you get to the point where you're super successful and everybody knows your brand, and so there's a value in the brand, obviously Nike and Coca-Cola have significant brands, but there are some people who have, the website is well known and all that stuff. Then what we can do is we can actually move that valuable asset with the brand, for example, or the website, outside of the management LLC, because again, that's anything that's inside is going to be fair game. So I can move that out, hold it somewhere else, maybe hold it in the holding company, and then just lease it back or give a royalty. So you have the right to use the brand name, but it doesn't actually own it. So that again, when the management company gets sued, if you want to keep that brand for whatever reason, you still own it over here, and it's not going to be subject to whatever judgment is going to happen over here. But this is the key point. We always want to separate the management LLC from the holding LLC. And that's really the main reason I do this. Now, the other thing that I often see is people, in terms of the ownership of this management LLC, they put the holding company over here, which I also don't like to do, because especially when it's just one person or maybe two, there is always the chance that although it's a difficult chance, but there is always that outside chance that they are able to pierce the corporate veil. Maybe you didn't follow the corporate formalities or whatever. And so if they were ever going to pierce that corporate veil, I don't want them to end up here, because that's in the holding company, because that's where all the valuable assets are. So ideally, this is going to be, if there's multiple sponsors, the owner would typically be your own individual management company, right? So let's say there's 3 sponsors that get together. You guys have each your own LLC, your own management LLC, your own branding, where you have your website. You get together and create this management LLC. I would have those 3 management companies be the owner of this management LLC. And over here on the holding side, you want that to be you guys individually, or a living trust, if you have a living trust. And to the extent you have an asset protection trust, which we can maybe talk about in the Q&A, then that's where the asset protection trust would end up being. So the holding company would be owned by an asset protection trust that in turn then would be, you actually wouldn't own the trust, you would be the beneficiary of the trust. Which kind of reminds me of maybe the last point I'll bring up before I open it up to Q&A, which is a living trust has 0 asset protection value, absolutely no asset protection value whatsoever. And so a living trust sole purpose is to avoid probate, which has a ton of advantages, obviously, privacy, time, money. But from an asset protection standpoint, it's not going to protect you 1 iota. The only trusts that are going to protect you are what we call asset protection trusts, because they are irrevocable trusts, meaning once you set up those trusts, you cannot change them. As opposed to a living trust, you can change it every day if you wanted to, and change your mind and change the beneficiaries and change, all kinds of stuff in there, which is why it loses its asset protection value. That's where I think I'm going to stop. I mean, this is, again, you can go so many levels deep, and maybe towards the end, I'm happy to kind of go into that larger discussion. There's a lot of other strategies that we can implement, but 90% of the time, you're going to have this structure. One other point I'll mention before opening it up to Q&A is that there's no reason to have a different holding company or a different management company for every single syndication that you're doing. You can create, assuming it's just yours, if you create a management company, you can have that manage the syndication, your next deal, the next deal, the next deal. The only time you wouldn't do that, obviously, if you've got other partners in that management LLC and they're not going to come with you on the other deals. But assuming it's just you, for example, or you and a partner that are going to be involved in every single deal equally, then there's no reason why we wouldn't recycle, for lack of a better word, the management LLC. And same thing with the holding company. Most people just kind of have one master holding company that will own all of your safe assets, whether it's the syndication LLCs, whether it's your property LLCs, your cash, your excess cash, your savings, your precious metals, whatever you have. Some people like to separate sort of the business stuff from when I say business stuff, the business valuable assets from the personal valuable assets, but you could have the same holding company. I'll tell you, in my situation, I've got one master holding company that owns all of my safe assets. I wanted to give, I'm going to turn this over to Bethany, and actually I do see our good friend Tony Castronovo in the house, and want to give, we had a couple of questions that were submitted ahead of time, so I wanted to kind of give priority to those questions. And so Tony, do you want to unmute yourself and ask your question? And then Bethany, I'll let you take it from there.
Thanks, Mauricio. That was a great presentation. I actually didn't have it pulled up here, but I'll go from the cuff. I think it was really around sort of the benefits of setting up an LLC that is either Delaware or Nevada. I know you touched on Delaware just a little bit. I've heard that there's advantages, but I don't know what the disadvantages are. And then it's kind of a two-pronged question, because the other part of the question is, should I form an LLC that is really more of that specific LLC for the property? Should I form it in the state where the property is, or the state where I'm running my business from?
Great question. Let's do it reverse. So the first one is the second one's a quicker. So the property LLC is usually set up in the state where the property is located, because that's where that property is actually doing the business. I mean, you're going to pay taxes in that particular jurisdiction. So wherever the property is located, in my ideal world, that's where you're going to set up the LLC. So in my example, Atlanta, Georgia LLC, Dallas, Texas LLC. Now, where your business is located, that's most likely your management company or any other business. Then you're gonna register that in the state where you're actually conducting the business, which is usually the state of your residence, right? So if I forget where you live, Tony,
Texas.
but I live in Texas. So you live in Texas. So if you have any kind of an operating company, that means you're doing business in Texas. And again, that's where I would set up the business LLC, is in the state that you reside. So if you're buying a property in Florida and you're running it from Texas, I would set up a Florida LLC to hold the property. And then I would have your sponsor company or management company be set up in Texas. As to the other states, I would throw in Wyoming into the mix. Wyoming, Delaware, and Nevada are by far from the holding company. Right now, we're talking holding company, the safe place. Those are the best states, especially if you're a single member. One of the things we did not talk about, because it gets a little bit esoteric, but the reason some of these states are so powerful, like the Nevada, Delaware, and Wyoming, is that they have charging order protection, which I think all states have charging order protection. Let me talk about charging order protection, because that's an important piece that I probably should have mentioned in the presentation. But charging order protection is the key when it comes to all of these domestic entities. And what a charging order simply is if I get let's just use Tony's example. If I get a judgment against Tony, I do not want to get a charging order, because that means I am going to be limited to putting a lien on his entities, right? I'm not going to get control of his entities. I'm not going to get ownership of his entities. I'm not going to have anything to do with his entities other than get the distributions that were going to Tony. Those will get diverted and come to me as the judgment owner until my judgment gets paid off. But I have no control and no ownership. And that's the last thing I want as a creditor, because the first thing Tony's going to do is cut off any distributions to himself, because why would he send distributions to himself if those are going to get diverted to me? And so what you are looking for as the syndicator is a state where not only is there charging order protection, which is what we want, but that charging order is the exclusive remedy. Because, for example, the great state of California, which is probably the worst asset protection state, they have a charging order language in their statute, but it says that the judge may issue a charging order for the benefit of the creditor. It may also not. It may also give them the ownership of the LLC, may give them whatever they want. I mean, it's probably the most broad. So we're looking for states where charging order is the exclusive remedy. That's the only thing a creditor can get from you, is that charging order protection, which about half of the states have that. Texas is one of them, for example. But the reason those three are really powerful is that that charging order protection doesn't necessarily extend if it's just a single member LLC, or if it's a husband and wife, which is considered a single member, which a lot of holding companies tend to be. And the reason for that is because from a public policy standpoint, it doesn't make any sense. The reason the charging order even exists is because, think about it. Let's see, Tony and I, I'm going to keep picking on you, Tony. Tony and I are in business together, right? We have a business, and Mauricio gets into a car accident, and there's a $10 million judgment against Mauricio that I can't pay. If my creditor was able to get my 50% ownership in our business, well, now the creditor's a 50% owner with Tony. And Tony doesn't want to be in business with the creditor. The creditor doesn't want to be in business with Tony. The creditor just wants to liquidate everything to get paid. So there's a public policy against giving creditors ownership in entities, so that we don't have this issue. That policy doesn't really make sense when it's just a single person. When there's one person in the LLC, that public policy doesn't make sense. And when there's a husband and wife, it doesn't. So there's only 3 states, Delaware, Nevada, and Wyoming, where charging order was specifically extended to single member LLCs, which is why those states are so powerful. It doesn't mean that you may not get it in other states, but those are the states that literally ran back their lawmakers ran back and amended the statute to specifically say that charging order protection actually extends to single member LLCs. The reason that I prefer Wyoming, to be honest with you, so from an asset protection standpoint, any of those is great. The challenge with Delaware is that there's a franchise tax, right? I think it's $250 a year, so it's a little bit more expensive. The issue with Nevada is not lately, maybe in the last, 5, 7, 8 years, they added all these licenses and fees, and so now it's like $500 to just renew, because you've got to have a business license and you got to have all these, I forget what the annual reports or whatever. So it gets really expensive. Wyoming is still the simplest one. It's really inexpensive. And what I love about Wyoming is, number one, it's privacy. Wyoming the state of Wyoming has no idea who you are. Like if you go on the website and you look at, they don't reveal who the owners are. They don't reveal who the managers are. And you literally could walk into the Wyoming Secretary of State, I don't know if I should say this, with sort of a gun pointed at somebody and said, give me the information. And they don't have it. Right. So from a privacy standpoint, now they can get it because there's a requirement of the registered agent to maintain that information. So to the extent they need to get it, they can pick up the phone and call, but it's not like it's available to the public or in any given time. And then the other reason, that's one of the reasons I love Wyoming. And then the second reason I love Wyoming is because most people are really terrible at keeping corporate records, resolutions, annual, every time you make a decision, document all that stuff. And Wyoming specifically says that failure to keep corporate records will not blow your protection. So between the privacy and that little thing and the inexpensiveness, if that's a word, of Wyoming, that's why I prefer Wyoming. But look, if you live in Nevada or you live in Delaware, I would go there for sure. And if somebody comes and says, hey, look, I want to be in Delaware, I'm certainly not going to push back. To me, they're all pretty much equal. And so there's really the disadvantages, I think, to really answer your question, is just the cost of Nevada and Delaware. Other than that, they're all pretty much the same.
Fernando Baez has a couple of questions as well. Fernando, do you want to unmute yourself and ask?
Okay. No, my question is, what happens when I have a deal where I have multiple other co-sponsors? So they should be part of the management company as individual or as a company, and on the holding company side, they should be inside the same holding company, or I have the holding company and they use are at my side either as individual, LLC, or any business figure you want to use. I mean, how do I protect from those other co-sponsors doing a deal with me?
Yep, and I'm going to repeat the question. I got it, but I'm just in case. So the question basically is, what happens if you have multiple co-sponsors? How do you set that up with your management company, your holding company? If you have more than, I would say more than two people, two co-sponsors, it makes sense to set up a separate management company. That makes it easier on the docs, on the explanation of the investors. So if you've got you and let's say three other people, I would even say two other people, create your own management LLC, separate management LLC just for that project, right? But if it's just you and one other person, for example, you have the option. You can either create a new management company that's owned, let's say it's 50-50 by the two sponsors, or you could just have co-managers. You could have, your personal, management company could be a co-manager along with your co-sponsors. And if you have a third person, theoretically, you could almost get away with three co-sponsors, right? Co-managers, I mean, but after that, it gets really tricky. So if you have, and these days I'm seeing it's even rare to see sponsors under three, but so most of the time we will create a separate management LLC that's owned by the 3 or 4 or 5 or 10 sponsors. And then the owner of that management company would be your individual management LLCs. Not everybody, but most people have a website. So whatever that website is and your business card and you're the managing partner or the CEO of whatever that entity is, that's your management company or your sponsor entity. That should be the owner of that management LLC. When it comes to the holding company, most of the time, everyone has their own holding company because, again, as I mentioned, your holding company is not going to be just for this syndication. It's going to be for multiple other assets. So typically, we would see, let's say the carried interest is 20%, and let's say you've got 3 people in there and they're all equal. Then you would have 3 holding companies, or sometimes they just want to hold it in their own personal name. But you would have 3 separate, let's say, holding companies, each owning 6.8% or whatever the number is that get to that 20%. But you can also create a special, especially if you're going to do deals together, multiple deals together, it makes sense to create a holding company with the 3 of you or 4 of you, so that that same holding company will then own that 20% along the way. Again, if you're in a state like mine in California or Georgia, you're better off having a multi-member LLC anyway. So having a holding company with multiple members is a stronger asset protection play. So that's another advantage of having one holding company owned by the sponsors individually or their living trust. But it's common for us, again, it's often that somebody already has a holding company, so they tend to just do it in their own personal holding company.
No, all that is clear, but what happened in the scenario that I have a holding company and the person next to me doesn't have a holding company? Is it okay if I run this with the other person under his name or a regular LLC?
Yep, it doesn't affect you it doesn't affect you at all. So if you have a holding company, you're going to hold your 6.8% in a holding company, and the other 2 co-sponsors don't care about asset protection or don't want to do it, and they want to hold it on their own personal name. That's their call, and that's not going to affect you one way or the other. Because the holding company only comes into play if you get sued unrelated to the syndication. It's if you get into a car accident or another car dispute or a bar fight or whatever, that's when the holding company comes in play. So if they're suing you specifically, it's not going to affect your other 2 partners if they end up doing it separately.
Jason Lewis has a question. Jason, if you want to unmute yourself.
I think you might have answered my question in the charging order example, but I'll go ahead and read it anyways. If an LP holds their interest in an S-Corp, does that create any liability for the syndication LLC? For example, a lawsuit happens to the S-Corp, can they come after the syndication LLC and force a sale or do anything?
I don't represent the investors. I mean, so if they're going to hold it in their personal name or, whatever, I don't care. If they were to hold it in an S-Corp or an LLC taxed as an S-Corp, it's not going to affect the syndication whatsoever. But the point I was going to make actually is that even if you want something as an S-Corp because of tax purposes, that would not be a holding company. That would not be a passive investment site, but it would, and this is kind of, I'm getting into tax things. So I'm not a tax advisor, my disclaimer. I don't play one on TV, but from a tax perspective, there might be some benefits to having an S election, which is a pass-through, but corporations don't have charging order protection. That's why we usually don't like corporations to hold your valuable assets, because if I get sued, I can have the judge hand over the shares or the stock, just like I could if I had Apple stock. And so we don't want to hold entities, valuable assets in a corporation. If you need the S election, the nice thing about LLCs and LPs is that you can have it taxed however you want. So you can have an LLC taxed as a partnership. You can have an LLC taxed as an S-Corp, make an S election. You can even have an LLC taxed as a C-Corp. So that's one of the beauties and flexibilities of LLCs. But the last thing you want to do is hold valuable assets in S-Corp, because you will have no charging order protection except for the great state of Nevada. So Nevada is the only, and to be completely frank, I haven't looked at it in probably 2-3 years now, but last time I checked, they were the only state that had extended charging order protection to corporations. And so if you find yourself, and this has happened before, if you find yourself in a situation where you currently have your valuable assets in a corporation or an S-Corp, and you want to transfer it, or what's the right word? We want to convert that to an LLC. That's a challenge, because from a tax perspective, they're going to consider that as a sale. So you're going to have a bunch of taxes to pay. And so one of the strategies we were using is we would actually re-domicile that S-Corp or that corporation to Nevada, and thereby gaining that charging order protection in the state of Nevada. Yeah, great question on the, but it's not going to affect anything if whatever your investors end up how they hold their entity is of no concern to the syndicator, other than you obviously want to provide value to your investors. So it may make sense for you to mention it to them. Hey, you may want to create an LLC or something, but from your perspective, it doesn't affect your exposure.
But in your example about the charging order, you mentioned that they would only get a distribution. They wouldn't get ownership. But you're saying if they had their member interest was held by an S-Corp, they could in fact get the ownership, correct?
Yeah. Charging order only is a concept that comes from LLCs and limited partnerships. It does not extend to corporations. So when you own a corporation, you own shares in the company. If there's a judgment against you and you own shares in a company, they can request the judge that you turn over those shares, just like if you own shares in Apple or Tesla or Google or whatever. They would have an order saying, hey, Mauricio, you have a judgment and you've got these shares over here in this corporation that's valuable. Hand those over to the creditor until that to satisfy that judgment. There's no charging order protection on corporations.
Dwight Isaacs has a question about what happens when you actually do get sued. What kind of roadblocks? Dwight, do you want to unmute?
If you could walk us through, I mean, I had another question, but I figured if everything is set up the way you say perfectly, and say in that instance where you were at Berkeley and you said like 6 students had perished because the balcony collapsed, can you walk us through the opposing counsel's train of thought on how he would attack us, or the way you had the structure or the entity set up to protect us? How can you put us, like, play devil's advocate?
Yeah, no, that's a great question. And I probably should have mentioned it somewhere at the beginning too, that if anybody tells you that a particular asset protection strategy or structure is bulletproof, you should probably run the other way. These are not end all be all. These are just maximizing your chances of minimizing negative effects. So for example, a charging order sounds great, which it is, but now your money's kind of trapped. Like, yeah, it's great that your creditor doesn't get the distributions, but you're also not getting the distribution. So that puts you kind of in a bind. How do you get your money out of that stuff? And so it puts you in a much better negotiating position, meaning that you, as most cases do, they settle. And so maybe there's a huge judgment, but they say, look, it's going to be really difficult for me to collect, or it's going to take forever. Let's settle for, pennies on the dollar. That's really what we're ultimately looking for. But it's not a bulletproof, system. It's just maximizing your chances. If you don't have an asset protection structure, you're much more likely to lose whatever you have versus if you have an asset protection structure in place. So from I used to be a litigator, right? I used to be a defense attorney, although I have done some plaintiff's work. So I used to actually work for, if anybody's up in the Bay Area, I used to work for sort of a well-known car accident ambulance chaser guy for a summer. But so the first thing that's going to happen, this is one of the reasons I love asset protection in general and why I like privacy. Privacy isn't in and of itself, have any miraculous benefit other than, you should always expect to be able to, when you put a really good asset protection structure in place, you want to be able to literally show the whole structure to the judge, open kimonos, here's what's going on, and it should withstand scrutiny. It's not something that we're relying on hiding or smoke and mirrors. But privacy, one of the reasons privacy is so great, which is one of the reasons we like Wyoming because of its privacy, is that most plaintiff attorneys work on what we call contingency fee arrangements, which means they don't charge an hourly. They're not going to charge a retainer and then bill for $200, $300, $400, $500 an hour. They're going to take a percentage of the judgment. And it's usually about a third. When I was doing these car accidents, he would take a third of any settlement. So if we settled for $100,000, the fee would be $33,000. And sometimes it goes up a little bit if you end up having to go to trial, because once you go to trial, it's a lot more work. And so maybe that's more like 40 or 50% of the judgment, but they're going to only get paid if they're able to collect. So the first thing a plaintiff's lawyer ends up doing is doing what we call an asset search. So if you get into a car accident and let's say I represent the victim and Dwight, you're the responsible party, you rear-ended my client. The first thing I'm going to do is do an asset search, because the last thing I want to do, no matter how great my case is, maybe you rear-ended my client, which, you know, it's almost, unless my client changed lanes at the last minute, it's always going to be your fault when you rear-end someone, even if I slammed on my brakes. And so I've got a clear-cut liability case. You know, my client broke their back and they've got all these medical, you know, it's a really solid case. But if I don't see a reward at the end of the tunnel that I can collect money, if Dwight's homeless, or, you know, I can't see assets, then I'm not going to go spend the next 3 years of my life going through the whole litigation process, getting a judgment, and then not knowing whether I can collect or not. So a lot of times, the first thing a plaintiff's lawyer does an asset search. And so they're going to do, there's things you can do. You can do bank account sweeps. You can obviously do a search on property to see what kind of property you own. You can do brokerage sweeps. You can go with next level and hire, you know, private investigators, kind of figure out what you have. And so if they can't find anything, the likelihood that they would rather settle for whatever insurance limits you have goes through the roof, versus if they do an asset search and see that you own this mansion over here and you've got all these real, you know, investment properties and you're this and you're the other. If they know that there's a lot of money at the end of the tunnel and they can get, you know, they can get a 7-figure judgment, they're going to do that. So that's where privacy makes a ton of sense. Now, in the example of the balcony collapsing, obviously whoever owns that property is I mean, that's almost like they're going to be responsible. So the owner of that building is going to be responsible. And then there might be I'm going to sue everybody I can find. So the property manager is probably going to be responsible because there's going to be some failure to maintain. I'm going to try and find every single person I can. But the owners of that building, number one, if it's structured properly, I won't even know who they are, right? And the beauty of it is that until I get a judgment, your ability to pay that judgment is irrelevant. So I can't actually ask you in the litigation whether you have an ability. I can't bring you in for a deposition or send you interrogatories to find out whether you have the ability to pay. That only becomes a relevant factor once I get a judgment. Everybody forgets it's a 2-step process. One is to get the judgment, which is great. But once I get the judgment, the next step is I got to go find assets and collect. And so only once I get a judgment can I then start bringing you in and asking you, you know, where are your assets? You know, I can ask you questions under oath, what's called a judgment debtor exam, and I can actually ask you questions about whether you have an ability to pay. But in that example of the thing, that there wouldn't actually be any way for you to even find out that I'm even the owner. And again, by merely being a passive owner, unless I've done something in terms of something that I've actually done, and that's the whole point of being a passive investor, even of the Class B, that you're not making any of the decisions. The decisions would have been made by that management company. The asset manager and the property manager probably failed to inspect the balcony or whatever the cause of that. And you probably, actually, now that I think about it, you're probably bringing in the engineers or whoever built the thing in the beginning. So there's going to be a lot of, and I can probably go back and look at it, there's going to be a lot of parties involved in that stuff. But if I'm just a mere owner, number one, they may not even find me and not see any assets involved. So they're not going to want to go after it. And they find out I have an insurance policy for a couple $1 million, that might work. But being a pure owner is not going to incur liability unless I've actually made some decisions that then led and caused whatever harm is being alleged.
Gotcha. No problem. And just to follow up, I know is that your operating agreement can be changed at any time prior to the judgment. So if you say, "Oh my goodness, my operating agreement is not as bulletproof as I want it to be, and I think this case is going to be tanked," let me call Mauricio up and right before the jury comes back and change it.
No, so that's a good point. So let's talk about that in a second. So my 2 favorite quotes that I often will quote. One is a JFK quote, which says the time to repair the roof is when it's not raining, or something. I'm sure I butchered that, but the time to repair the roof is when it's sunny, or something like that. And then Robert Kiyosaki likes to say the time to put your seatbelt on is before the accident, right? So once you have even the inclination that there's a dispute, that you have the potential to be sued, meaning you get a demand letter, or quite frankly, even if you just get into a car accident, potentially you're going to get sued, then at that point it's too late. Like if you do a transfer after the fact, after you've got a reasonable expectation to be sued, or you actually do get served with a demand letter or lawsuit, anything that you transfer at that point will likely be subject to what we call fraudulent transfer rules, which basically says the judge will be able to literally unwind whatever strategy you try to come in. So let's say you have no asset protection, you get into a nasty car accident, crap, I don't have anything set up. Let me go create a Wyoming holding company and let me transfer all my assets over to that Wyoming. At that point, it's way too late. The judge will see that and they will unwind that. So the time to do this is prior to even reasonably knowing that you have an expectation of being sued.
Okay, I think we got them all. I guess raise your hand if I missed you somehow.
Really, really appreciate you
Okay.
guys not only attending, but sticking around for an hour and a half. Bethany and I really, really love doing these and really appreciate you guys spending your Wednesday evening with us. And come back next week where we will be talking about how to legally bring in capital raisers to your sponsor team. Capital raisers in air quotes. All right, guys. Thanks, everyone. We'll see you next week.